Good day. I'm Mohammad Yasin Khan Durrani, and this is my student ID card. My student ID number is 230-507-49. Today I am here to deliver a comprehensive legal analysis and provide expert advice to Harim Jules concerning their contractual dispute with Rivaj UK. Our focus will be dissecting the intricacies of Sales of Good Act 1979, ensuring that Harim's Jews receive informed guidance and navigating this complex issue by mutuously examining their terms and conditions of contracts will assess the potential breaches and explore a viable remedies under the Act, ultimately empowering Harim's Jews to make well-informed decisions. Moving forward to the next slide. The situation involves a contractual dispute between Harim Jews and Rivaj UK entered around a bespoke order of hypoallergenic jewelry. Specifically, Harim Jews commissioned these custom pieces with the explicit expectations that they would be made from titanium given their hypoallergenic requirements. However, upon delivery, it was discovered that the items not only failed to meet this critical specification but also contained defects. Furthermore, the cookers provided were not in line with agreed upon description. When Harim Jews sought a refund, citing these issues, Rivaj UK refused, citing their store policy as justification for denying the request. This refusal has led to complex legal situation with potential breaches of Sales of Good Act 1979 has its core. Coming towards the next slide, our analysis will center three critical statutory implied conditions outlined the Sales of Good Act 1979, which were pivotal in determining the rights and obligations of both Harim, Jules, and Rivaj UK. Firstly, we will examine the condition of certificatory quality and section 14.2, including the specific expectations that may apply. Such these details in subsection 2C. This will involve assessing whether the goods delivered by the Rivaj UK met the standard and reasonable person would expect given the description and price. Secondly, we will evaluate the fitness for purpose under section 14.3, determining whether the goods were suitable for the specific person communicated by Harim Jules, particularly the requirements for hypoallergenic materials. Lastly, we will scrutinize whether the goods corresponding with the description provided by the Rivaj UK under section 13, focusing on the discrepancies noted in the cookers and other items. By dissecting these implied conditions, we aim to establish whether the Rivaj UK has fulfilled the contractual obligations and what will be the remedies being available to Harim Jews. Going towards the next slide, the concept of certificatory quality has defined under section 14 to the Sales of Good Act 1979 encompasses several key aspects. The goods should be safe for use, durable, and free for defects. The standard for determining certificatory quality is in the account the description of goods, the prices, and any other relevant circumstances. However, section 14 2C provide an important expectation notability under subsection C, which protects sellers from liability if defects were specifically drawn to the buyer attention before the contract be made, or if the buyer has examined the goods and should have discovered the defects. Relevant cases illustrate the applications of certificatory quality requirements in the Yasin versus Boyan, where the standard due to their unsuitability for the buyer specific needs highlighted the importance of goods meeting both general and specific expectations of quality and performance. This legal framework will be crucial in assessing whether the goods supposed by the Rivaj UK to Harim Jules meet the certificatory quality standards. Going towards the next slide, when a buyer clearly communicates a specific purpose or requirement to the seller and relies the seller expertise or judgment to fulfill that needs, the goods supplied must be fit and their particular purpose. The principle is underscored in the case of BSS Group PIC versus Makers UK Ltd, which highlighted the specific requirement when the buyer depends the seller's communicated the needs for hypoallergenic materials. Rivaj UK failure to deliver the goods meeting this requirement could constitute a breach under section 14.3, the Sales of Good Act 1979. Going towards Section 14 2C of Sales of Good Act 1979 provide that the good will not be considered of unsatisfactory quality if the defects were specifically drawn to the buyer attention before the contract was made, or if the buyer examined the goods before the contract and would have reasonably discovered the defects. This principle was illustrated in the case of Tornet and Fairbeer and Sons, where the court ruled that since the defects in the question was based upon the inspection, the seller was not in the breach of implied condition regarding the quality. This exception is relevant in Harim Jewels case if the Rivaj UK can demonstrate that Harims can aware of or should have reasonably discovered the defect before purchase. Under Section 13 of Sales of Good Act 1979, goods must correspond with the description provided by their seller if they constitute the breach of a condition entitling the buyer to reject the goods. The principle was illustrated in Eros Ltd versus E.A. Ronson and Sons, where timber supplied with the different dimensions that specific was denied a breach, allowing the buyer to reject the goods due to the failure of the match of contractual description. Similarly, in the Rivaj UK, goods do not match the description provided to Harim Jewels. It could constitute a breach under Section 13. Going towards the next slide, Harim has grounded to reject the entire order to multiple breaches. Firstly, the necklace potential allergy risk due to the non-titanium materials breaching the implied terms of fitness of purpose under Section 14.3. Secondly, the ring defects such as missing gems likely breaching the implied terms of satisfactory quality under Section 14.2. Thirdly, the cooker sets failure to match the contractual description breaching Section 13. These breaches entitled the Harim to reject the goods and seek remedies including refunds or damages. Going towards the next slide, in which we will discuss the given breaches identified Harim is entitled to. Firstly, the reject of the goods due to the non-conformity. Secondly, claim a full refund for purchase price. Thirdly, seek damages for any foreseeable losses resulting from breaches. Her rejection appears timely as it was made upon delivering a specifically highlighted the defects, further straightening her position. Going towards the next slide. The Rivaj UK store policy cannot suspend Harim statutory rights under the Sales of Good Act 1979 and the Customer Act 2015 exclusion and clauses attempting to limit or exclude the liability for the breaches of these rights are likely to void the Consumer Right Act. The cases of R&B Customers Brokers Co. Ltd versus Untitled Dominions Trust Ltd illustrates the court's approach to limiting the enforceability of such clauses against the customers, suggesting the Harim statutory rights remain enforceable despite any contrary policy claims by the Rivaj UK. Going towards the next slide, to enforce her rights, Harim should take the following steps. Firstly, the formal rejection provided by the Rivaj UK with a written notice. Secondly, the return of goods. Arrange for the return of the goods. Thirdly, the demand for refund and damages. Clearly demand a full refund of purchases prices and compensate for any additional losses. Fourthly, in the small claims court, if Rivaj UK refers, Harims can file a claim in the small claims court. By following these steps, Harim can effectively assert the rights. Going towards the next slides. This case discusses the illustrated key legal principle under the Sales of Good Act 1979. First, Yasin versus Boyan highlights the importance of certificatory quality under Section 14.2. Secondly, the Tornet and Fair versus Bears and Sons demonstrate the expectations under 14.2c regarding known on observable efforts. Thirdly, the BSS Group PLC versus Maker UK Ltd emphasizes the fitness for the purpose. So fourthly, the Eroses Ltd versus Ronson, and fifthly, R&B Customer Brokers Co Ltd versus Entitled Dominions Trust Ltd shows the limitations on exclusion clauses under the Unfair Contract Terms Act 1979. Going towards, in summary, Harim has a strong statutory rights to assert. Firstly, promotely the reject the good in writings detailing the breaches. Secondly, return the goods and demand a full refund. Thirdly, claim damages for any additional losses. And fourthly, if necessary, purpose legal action through the small claims court. Thank you.